Okay, tēnā koutou katoa. Dobry den, Susie. I'll skip the potpourri, we're short and etc. I'll get straight into the substance of this, since the time is so short. My field is legal history. What is that? You may be wondering if legal history is a branch of law or is it a branch of history? It is a branch of history. As economic history is history that places that economic trends at centre stage, legal history is a branch of history that places legal developments at centre stage. So we legal historians are by definition multidisciplinists, or perhaps we're bidisciplinists. Economic historians have to have expertise in history and in economics, and legal historians have to have, or at least we claim to have, expertise in law and in history. So we straddle two major fields. Legal history is become a subject of great practical significance in Aotearoa today. That is largely because the inquiries of the Waitangi Tribunal, in striking contrast to the Native Title Tribunal in Australia, are by definition historical inquiries. Expert witnesses in Australia's Native Title Tribunal, that is apart from Indigenous experts and elders, tend to be anthropologists. In the Waitangi Tribunal, expert witnesses, again, apart from the tangata whenua speakers, tend to be historians. Moreover, because so much of the means, the methods, as Foucault would probably say, the micro-technologies of dispossession in colonial New Zealand were legal. For example, the confiscations that took place in Taranaki, the Waikato, the Bay of Plenty, the East Coast, were achieved by definition, by legal instruments, by the confiscation statutes and by the compensation courts set up under the confiscation legislation. Equally important in the tribunal process are the operations of the Native Land Court. So two major legal processes are at the centre of the tribunal inquiries. Virtually every tribunal report comments on the Native Land Court to some extent, and many focus on the confiscations. I've spent much of my career as a barrister in the Waitangi Tribunal, representing claimant groups, and I've also spent a good part of my career as an expert witness in the Waitangi Tribunal and in the Māori Land Court as well, presenting historical testimony. This has also fed into my academic teaching, writing and publishing. In the law schools, the students take a course called jurisprudence. Contrary to what some people appear to think about what we do in the law schools, we don't actually train students how to win cases in court. That has to be learned on the job while in practice, as I found. Also tends to be, cases are about facts and evidence, much more than they are about law, something else that aspiring barristers quickly find. No, we teach the law, the content of the law, most of it being reports of cases, some of which are contemporary, others of which go back to medieval and Renaissance England. In Europe, they learn about Roman law as the foundational system and spend a lot of time on translations of the classic works of Roman law dating back to 6th century Constantinople. Jurisprudence is the course that is a kind of inquiry into philosophy of law. What is law? What does it mean? What is it meant to say to have a legal culture? What is law by its nature? Where is the law to be found? Some of the law can be found in the formal sources, the positivist sources, as we say in jurisprudence, in the statutes, in the Acts of Parliament, and the court rulings, but only some. Typically, legal historians are concerned with the history of those positivist sources, with the history of the case law, the courts, the legislative instruments, the statutes, or to some extent with the records of the legal profession. But I am a legal historian of Aotearoa and the Pacific. What then of tikanga, or its equivalents around the Pacific and in the Americas? Question is, who owns legal history? Does only the United Kingdom, does France, Germany, the United States, are only the Anglo-American, the Western European cultures the only legal cultures to have histories? Most recently, I've become fascinated with the legal history of tikanga and the legal history of Indigenous law in the Pacific. Most studies of Indigenous legal systems, customary systems, tend to be synchronic studies in the anthropological guise. The Malinowskian anthropologist goes to the remote beach, sits there amongst the Indigenous community, immerses him or herself in the language, the culture of that group, and having done that, then inquires about the rules. How do you guys do this or do that at the present time, at the present day, in terms of your customary law? Most studies of customary law tend to work on that basis. But what about that's the synchronic version. What about the diachronic version? Is there a history? Who owns legal history, and how can it be found in somewhere like Tahiti Nui or Hawaii or Aotearoa? I don't mean only the colonial period. What about before that? Then one of the most exciting trends in Pacific studies, Pacific archaeology at the present time, is the question of states. There's a growing literature on state formation in the pre-European Pacific. We all know that at the time of colonisation, there were state formations, that Tonga, that Hawaii had formed kingdoms in the 19th century under the influence of the Bible and missionary teachers. We have the Kingitanga movement in New Zealand as our parallel. But what about before then? Were there states in the Pacific at the time when the first European navigators showed up? This is a new field of inquiry, a new field of approach in historical anthropology in the Pacific. The consensus that is now emerging is that there were. Pat Kirch, for example, prominent Pacific archaeologist, based for a long time at the University of Hawaii, but who then moved to Berkeley, is one of the pioneering scholars who's written about states in the pre-European Pacific. The most obvious candidates for states in the pre-European Pacific are Hawaii and Tonga. That these cultures created powerful entities which were once described as chiefdoms, but no one could ever quite explain what a chiefdom was. Kirch and his colleagues have come to the conclusion that we can accurately call these very powerful entities states. Of course, we're then driven back on the question of what is a state, and that is one of the most perennial questions of sociology and social science, and I'm not going to explore that. There have been so many definitions. But Kirch and the archaeologists tend to focus much more on, as archaeologists, on material culture, on what we can see today and infer from the scale of what we can see, whether anything you would need something sufficiently powerful, well organised, to be characterised as a state that could create such a thing. Kirch has in mind the incredibly complex irrigation, dryland irrigation systems on Hawaii. Personal example, we were on a family trip in Samoa. We travelled along the coast of Savai. We talked to the landowners to go to this particular place. They cleared a path for us with their machetes, and we found on the south coast an absolutely gigantic stone platform. And I mean gigantic, built out of lava blocks on the south coast that towered over the coast, and you would have been able to see it for miles. What kind of entity, what kind of political entity could have built and organised something like that? This has implications for law. When we talk about pre-European states, then it seems reasonable to deduce from that. Then such entities, these states, if they are states, then they must have had public law. At some point, we cross a boundary between, tributes, supposedly chiefdoms, are tributary tributes. They have to be paid to the chiefs. When do tributes start becoming a tax? That is quite clear in ancient Hawaii. There were specialist chiefs, the konohi, who had the task of managing the estates of the royal dynasties, of collecting the revenues, of distributing them to the central authority. When does family relationships, whakapapa, become public law? Who is entitled to claim rights in the throne, in the government, in the state, and to use a neutral example of the polity. States imply public law. I should add also urbanism. It's now the most interesting research in Tonga lately is now saying that we have to think of pre-European Tonga as an urban society. So all this is changing the source material of legal history. We are looking at powerful entities, powerful polities that had legal histories, which we can reconstruct by means of language, linguistics, by careful study of the POLEX databases to infer political cultures of ancient Hawaii from which all these polities depended or originated. So that is what I'm working on, what I am exploring. It's a new, I hope, legal history. Thank you.